Good evening, everybody. Thank you for joining us for our 2025 review of 2024's patent cases. My name is Dominic Adair. I'm the partner in charge of this production and the editor of our review. I'm joined tonight by Nadine Bleach and Katie Cambrook. Katie's an of-counsel, Nadine a senior associate at Bristow's. Here's our agenda. It's the tried and tested agenda, so I'm going to say a few words on statistics first, and then I'll hand over to Katie and Nadine to alternate with a case countdown. And we always start with a look at the faces of the judges that decide our cases. So here are the faces of 2024. Immediately you'll see there are no Supreme Court judges pictured. That's because we didn't have a Supreme Court case in 2024. But the Court of Appeal was reasonably active, and so you can see there joining Richard Arnold and Colin Burse. We've shown judges who've heard at least two cases, so quite a few other Court of Appeal judges active, but these are the busiest judges. So also pictured alongside Richard Arnold and Colin Burse, we have Stephen Phillips, Christopher Nugee and Andrew Moylan. Going down to the Patents Court, Richard Mead still judge in charge. James Mellor also the other busiest Patents Court judge and one of the judges doing the technical cases alongside Richard. But the two new faces that you may not be so familiar with are judges who've heard at least four cases, so pretty busy. That's Anthony Zaccaroli, who is now a Court of Appeal judge. He went up in October. And Jonathan Richards, who is a fairly recent appointment from January 2023, and interestingly for the bench, a former solicitor. So he was a tax specialist in his earlier life. We're showing Richard Haycon in the IPEC, although as I'll go on to say, he had mainly Patents Court cases during the year. So on to that and look at the numbers. 68 decisions in total. That's everything, all the smaller interim decisions, cost decisions, case management decisions, and a number that's exactly the same as it was last year, and not too far out of step as a total. So that's about right. 16 first instance judgments, probably also about right. 14 of those in the Patents Court, 2 in the IPEC. So that's the full judgments of substance on the merits. We've got 35 judgments, on interim measures and consequential issues, so notable decisions, but obviously not decisions on the merits. And then on the appeals, we've got 8 of substance, and that's quite a bit down on last year. 2 of those related to IPO cases, but importantly, not that we're not counting the IPO cases get appealed to the High Court first and then the Court of Appeal. These are Court of Appeal decisions on IPO cases. And counting them together, there's 8 substantive appeals. In terms of subject matter, we always say telecoms and life sciences dominate. Well, this year, for the second year, it was telecoms dominating a lot more than life sciences. So if you're a life sciences specialist tonight, you'll have slightly less than a 50% share, I'm afraid, of our cases. If you like telecoms, you're in for a treat. And a new stat this year, we thought we'd look at the cases issued just to sort of check in on what we might see for next year and the following year. 14 new cases were born in 2024 compared to 45 in the previous year. Okay, and so when I say things aren't drastically out of step, this is the history chart that shows you why. So although it looks like a bit of a drop down, well, it is a bit of a drop down from last year, which was a busy year. It's not out of step historically with the output of the court. So you can see we're at the same level or a bit higher than about 2017, 2018. And looking at the size of each bar, the yellow bar is the Patents Court. So 14 decisions of substance there is historically about right. And actually, even 8 at the Court of Appeal, although it's sort of less than half of last year, is actually about right when you look back over history. So that's quite interesting, I think, to see that. In terms of the individual judge outputs, we said last year that Richard Mead was the busiest, in fact, double anybody else. That remarkably remains the same. So there he is at 12 cases. Mr. Justice Mellor at 7. The speed at which judgments are produced has improved quite a bit. It's not perfect still across the judges. Some judges are faster than others, but the speed at which judgments are produced isn't the whole story here. I think it is genuinely a case of some judges being busier than others. Now, I'm afraid not great news in terms of outcomes when it comes to how many patents were held valid. Things last year took a tick upwards, and obviously what goes up must come down, but it has come down immediately this year. So we are down at just over 20% of patents being held valid, so a pretty tough year for patentees in the UK. Now, this is taking validity and infringement as separate issues. I'll come on to show you in the next slide what happens when we take them together, but undeniably the courts were tough on patents last year. A bit kinder on infringement, so the infringement trend has ticked upwards a little bit and just crossed the 50% line. And infringement, as you can see from this graph, always trends a little bit higher than validity. The sort of lifetime trend is about 60% for infringement and is sort of being pulled down a little bit further down on validity to below 40% now. But that's a tough figure for patentees, and not really any immediate explanation for that. There wasn't any one case that had a load of rubbish patents in it that was just bringing the trend down. It was, it's hard to say exactly why that happened. I think it's just obviously luck of the draw that year. The cases in dispute. So we're going to switch now to looking at validity and infringement together in suit. So these numbers are patents now that we're looking at. So and as you go clockwise around the circle, things get progressively worse in the nature of the outcome for the patentee. So the best outcome for the patentee is valid and infringed. We have 4 patents held valid and infringed out of a 17 count total. Then next best, valid, not infringed, that's 2. The dominant outcome is the second worst for the patentee. That's invalid and infringed. Not much use in being infringed, I suppose, if it's invalid, but the patentee at least won on infringement. And then the worst outcome of all, invalid and not infringed, accounts for 5 of those cases. And going a bit more granular still, in terms of the individual grounds of challenge, this slide shows the kill rate of the various grounds of invalidity pleaded. So the way this slide works, if you remember, on the navy blue bar on the left is the number of times the allegation was made, pleaded. The green bar on the right is the number of times it succeeded, and that's displayed as a percentage in the orange circles. And if you like, that's the kill rate of the attack. So unsuccessful, unpatentable subject matter, that's a very difficult ground on which to succeed. So it was pleaded once, that didn't succeed. Anticipation or lack of novelty, 27% of cases succeeded on that, which is actually not a bad number for lack of novelty, given how hard it is to succeed on lack of novelty in the UK, although it is actually down on last year. Last year there was a remarkable figure. I think it was 43% of cases were anticipated, and that was sort of ridiculously high. 27 is still pretty good for anticipation. Obviousness is where the damage has been done last year. Almost 70% is brutally high. It's normally a high number in the UK, but this is really much higher than we've seen before. I mean, last year was an outlier in that it was only 20%, but it normally trends at about 50 to 60%. So 68% is tough. A very high kill rate for lack of inventive step. And then the other 2, insufficiency and added matter, that's probably about what we'd expect for those grounds. So pretty much on trend for those 2. So that's enough for me. I'm going to reappear at the end to tell you what's coming next. But in the meantime, I'll hand over to Katie Nadine to begin the top 10 countdown.
Thank you, Dom. So first up, and in at number 10, we have one of the life sciences cases. And this was a case that was brought by Samsung to revoke a patent owned by Janssen for treating ulcerative colitis with an anti-IL-12, anti-IL-23 antibody, ustekinumab. The patent relates, as is clear from the slide, to the blockbuster drug Stelara. The patent claimed the use of ustekinumab in a particular dosage forms and frequencies in an induction and a maintenance phase, which is the manner in which these kind of diseases are treated. At the priority date, ustekinumab was in phase 3 clinical trials for the treatment of ulcerative colitis, and it had also already been approved for the treatment of Crohn's disease. There were some key issues in the case which related to common general knowledge and the skilled team, but we're going to focus on those in relation to primarily obviousness over an abstract and a poster, and also a set of slides which were referred to as the SANS slides. So what happened? The patent was found to be obvious over the disclosure in the slides, but not over those in the poster and the abstract. So the poster and the abstract disclosed kind of emergency treatment of small numbers of patients in a kind of retrospective manner. And they were held not to give the requisite reasonable expectation of success that the treatment of ulcerative colitis would be successful. The slides, on the other hand, reported on the phase 3 clinical trial results in the induction phase for the treatment of ulcerative colitis. And the judge held that that did meet the level of reasonable expectation of success. Although the data was only provided for the induction phase and not the maintenance phase, he wasn't presented with any evidence that in other trials for medicines in this field or related fields, there had been a failure of success in the maintenance phase after the induction phase. So that was one factor that counted against Janssen. Separately, the judge also made a note that the data in these trials was from a reputable source and that the data itself was statistically significant. I think it's worth pointing out that the assessment here was really quite factual based. Obviously, all cases of obviousness are, but the facts in this case were that Janssen couldn't defend or didn't defend an earlier priority date, and because of that, these slides became prior art. So, why is it important? It cements the view, that really in the English courts, that there's no carte blanche for a finding of obviousness if a clinical trial is ongoing or a clinical trial protocol is out there, and no general rule to be applied blindly is what the judge said. In particular, he said that considering that a phase 3 clinical trial was ongoing based on some prior phase 2 trial or data which may not be known to this person skilled in the art, would leave them on shaky ground. And to devolve even a rebuttable presumption that approval from the ethics committee would give you any expectation of success shouldn't be done either. So, as I said, it's quite a fact-based assessment, and the data and facts in this case were such that there was this kind of loss of earlier priority or priority that wasn't defended, but there were some points of principle there which I think the judge picked out. One final mention on this case, there was a reference to claim interpretation and when it's possible to look at the description and to interpret the claims. Samsung's counsel in its opening argument had made a comment that they considered the Court of Appeal judgment in Sekiro, Lord Justice Arnold had seemed to indicate that you should only look at the description to interpret the claims if they were unclear. But the judge in this case took a point to mention that that's not his interpretation of what Lord Justice Arnold was saying, and that you can look at the description to interpret the claims for claim construction at any time, and it doesn't have to be if the claims are only unclear. And I mentioned that particularly today in light of the hearing that's going to be happening tomorrow morning in G1 of 24. So we'll see what happens there.
So next up at number 9, we have the Lenovo and Ericsson decision, which relates to preliminary injunctions. And so this came about because Ericsson had brought proceedings for infringement of their standard essential patents in Brazil, Colombia, and the US. And as part of that, they were seeking injunctions. And they also sought that the US determine FRAND terms for their portfolio. In response, Lenovo started proceedings in the UK, and they were also seeking determination by the UK court for a FRAND cross-license. And another thing they were seeking was a preliminary injunction, and that was on the basis of Lenovo's own patents for acts carried out by Ericsson in the UK. But it wasn't any usual preliminary injunction that they were seeking. Rather, they were seeking one with 3 provisos. So the PI would be enforced unless either Ericsson undertook to enter into a cross-license and undertook not to enforce any of its injunctions sought elsewhere, or agreed to enter into an interim cross-license or some other mutual agreeable interim regime. And the preliminary injunction was refused at first instance by Mrs. Justice Bacon, as it was characterised as anti-suit relief by the back door, because the 3 provisos that Lenovo was seeking for their preliminary injunction were all directed at trying to stop the relief that Ericsson was seeking in the proceedings elsewhere. And Mrs. Justice Bacon thought that is not an issue for a preliminary injunction. This was then appealed to the Court of Appeal, who unanimously dismissed the decision, the application. It was Lord Justice Arnold who gave the lead judgment. And it all came down to the American Sanamid test, which is the one used for determining whether a PI should be granted. And the key was how Lenovo were trying to state that there was a chance that they wouldn't be adequately compensated in damages or royalties under a cross-license which was eventually entered into. And so their argument was all that because Ericsson was seeking these injunctions in Brazil and Colombia, which are some of Lenovo's biggest markets, they're forcing or coercing Lenovo to enter into a license at rates which are higher than the FRAND rate, so a super FRAND rate. And the real issue for Lenovo was this disconnect. So the thing that they were alleging was causing unquantifiable loss were the proceedings in Brazil and Colombia, where there was a high pressure due to the injunction sought. And that was different to the alleged acts of infringement, which were Ericsson's sales in the UK. And so they didn't succeed under the American Sanamid test. And the Court of Appeal noted that really what Lenovo are trying to do was to create a lever in negotiations rather than really to stop Ericsson with infringing acts in the UK. So it's an important decision because it clarifies the American Sanamid test and that it is applicable to standard essential patents cases as well. And it shows that the real key is whether the loss relied on is caused by the alleged infringement, which here it wasn't. But the interesting point about this case is that the court left the door open as to how to deal with these issues where standard essential patent proceedings have been started and there is going to be some time before the FRAND determination of what should happen during that time. Because the court thought, well, it is potentially inconsistent with Ericsson's undertakings to Etsy and the fact that both parties were agreed that they would take a license on FRAND terms, that then Ericsson should pursue these actions in Colombia and Brazil. But the answer is not a PI, says the Court of Appeal, but there may be another role for the court in this area. We'll come back to that later.
So in at number 8 is our next life sciences case, and it's between Pfizer and GSK. In this action, Pfizer brought a revocation action to seek to clear the way to bring its own RSV vaccine to the market, because that's what the patent's related to. The patents themselves covered a stabilized F subunit vaccine, and this judgment, it's over 160 pages long, and covers pretty much every aspect of patent law. We won't be covering it all today. I'm going to pick out a couple of points from the infringement analysis and also look at the Arrow Declaration. So what happened? As I mentioned, there were two patents. They were both held to be invalid for lack of inventive step. That was a finding based primarily on what was the common general knowledge and what the skilled team would have been held to know at the time. And again, something that was quite fact specific. When it came to infringement, the judge held that even if the patents had been valid, they wouldn't have been infringed. And that came down to a look primarily at the claim language that we have on the screen here. So that related to a soluble F protein polypeptide comprising an F2 domain and an F1 domain, and in particular the definition of polypeptide within that claim language. Pfizer and their expert had argued that their vaccine related to two polypeptides and not a single one, and so under a normal construction there was no infringement. And also under the doctrine of equivalence, the judge held that this definition of polypeptide in the patent couldn't be overlooked, and the patentee must have meant that there would be strict compliance with the meaning of that term, and therefore, unfortunately, there was no infringement under the doctrine of equivalence because they failed on the third Actavis question. It's a particularly interesting case because we see an Arrow Declaration that was granted as well. The Arrow declarations, as you'll recall, are granted to do justice to the claimant, or you have to make consideration of justice to the claimant, to the defendant, whether they serve a useful purpose, and whether or not there's any other particular factor which points in the direction of whether they should be granted or not. We've recently seen several Arrow declarations being denied. This one was granted, as it mentions here, and they saw a declaration of obviousness, that it would have been obvious at the priority or filing date that you would have had an RSV antigen with the perfusion confirmation that was relevant, and that confirmation that would have been used to treat RSV-associated diseases. The Arrow was defended on the basis that of the non-obviousness arguments, which unfortunately had already fallen away. So they were left with arguments in relation to whether or not the Arrow would serve a useful purpose. And here that was kind of two-limbed in relation to public health arguments that were made. There was a difference in the approvals for the two vaccines, with the Pfizer vaccine being available for a maternal use as well as in the population aged over 75, and the GSK vaccine only for those aged over 75. To obviate the need for the Arrow, GSK had offered or said that they wouldn't seek an injunction in relation to the maternal use, but I think the public interest point had been of interest to the judge. He didn't give much discussion on it, but when he came to consider divisional applications that were pending by GSK, the evidence before him, and he felt that there was some uncertainty as to what might happen with those divisional applications, which may lead to Pfizer not being able to meet its any obligations to the UK market, and that might do damage to Pfizer. So the Arrow Declaration was granted. So why is it important? As I mentioned, the Arrow Declaration was granted, so they can still serve a useful purpose. It was also some interesting points on secondary evidence. We'll come back to secondary evidence in another case later today, but that's typically the kind of evidence of sort of a long felt want and points surrounding time between inventions and other avenues that have been looked at, which aren't, based on the primary evidence of the experts. Here, that kind of secondary evidence argument had been brought out only in the reply expert evidence and then run quite heavily in the cross-examination of the experts at trial. And the judge made some criticism of that. He didn't dismiss the arguments on secondary evidence out of hand because Pfizer hadn't made any complaints about it, but he did issue this kind of warning, which is on the slide. So as secondary evidence cases go forward, this might be one to take note of. There were also comments on the role of the skilled team and how different parties within that skilled team should interact. And that's kind of one of the hot topics from our side that we look at on a regular basis to find out what exactly the people on the skilled team should be doing and how close to the real situation that it needs to be when you're producing expert reports from more than one member of a team.
Right, next up we have the controller of patents and emotional perception AI. So a little recap about the facts on this case. So this all related to the question of whether an artificial neural network was a computer program as such, and therefore whether it fell under section 1.2 as an exception for patentability. So in this patent application, the artificial neural network was used to recommend media files to a user, and that was supposed to be on an emotional level. And the way that the artificial neural network worked, or was trained, was that it would look at files in a semantic space. So that's looking at the properties of a file as a user, as a human saw them, so the emotional qualities. So maybe someone's thinking, this file makes me so happy that I was going to dance. And then comparing that with the properties as could be measured objectively. So that might be the tone, the timbre, the speed, all those types of things. And so in order to train the ANN, it would adjust its weights and biases so that the measured properties would then match the semantic properties. And then it would be able to eventually produce a file which was on a human level more similar to the one which the human was currently using. So at the patent office, the hearing officer considered that this was not patentable and that artificial neural network was no more than a computer program. This was then appealed to the Patents Court, where Sir Anthony Mann heard the appeal, and he considered that an artificial neural network is not a computer program. And he also considered, and the main reason for that actually was because he thought that the way the artificial neural network worked was that it was applying its own weights and biases to produce the relevant vectors, rather than implementing a set of program instructions, and therefore it wasn't acting as a computer program. And in any event, he thought the artificial network had gone about its choice of files in a technical way, and therefore there would be a technical effect under the error-tell test. So this was then further appealed to the Court of Appeal, and it was Lord Justice Burse who gave the leading judgment. And he started off with the question of what is a computer? A machine that processes information, he says. And then a computer program, he said, is a set of instructions which cause the machine to process information in a particular way. Then he looks at what the artificial neural network is doing and says, well, that's the weights and biases in the artificial neural network are acting as a whole to instruct the machine to process information in a particular way, and therefore the artificial neural network is a computer program. But of course, that's not the end of the story. So under the error-tell test, was there a technical contribution? So he considered that the training element, where there was this pairwise comparison technique, did produce a useful system. But he thought that didn't make a difference to patentability because that was part of the creation of the computer program. And then when you look at the claim and the invention, all of the steps, all of the contribution was in the artificial neural network itself, other than the provision of the file to the user. And the way that the file was provided was a usual standard transmission. The contribution was that the file represented a better recommendation. But a better recommendation, said the Court of Appeal, is not something of a technical quality, rather that's aesthetic, subjective, cognitive function. And so the appeal was allowed, and therefore patent was deemed excluded subject matter and therefore not patentable. So, why is this important? It brings us back in line with the EPO, as Lord Justice Burst acknowledged in his decision. And it has caused the IPO guidelines to be re-amended, having been amended following Sir Anthony Mann's decision. The guidance is now that patent examiners should treat artificial neural network implemented inventions just like any other computer implemented invention. Of course, that doesn't mean that all artificial neural network implemented inventions will necessarily be unpatentable. It all comes down to the aerial tail test and whether the invention makes a contribution which is technical in nature, which will be determined on the facts of each case.
So, number 6, Pfizer and Unicure. This case was about a patent which was owned by Unicure. Pfizer had sought to invalidate this patent. The patent related to the treatment of haemophilia B. In little bit of background, that haemophilia B is caused by a mutation in a gene on the X chromosome. That gene encodes for a protein which is relevant in the coagulation cascade, and in particular to factor 9, or as it was referred to in the proceedings, and I'll refer to it today as FIX. Pfizer had sought to invalidate the patent over a single piece of prior art, and that was a prior published PCT application known as Stafford. Unicure's patent had claimed a type of the haemophilia B relevant protein, the FIX protein, with one amino acid changed in a position 338. This amino acid change was from an arginine to a leucine, which is relevant because the Stafford prior art also talked about changes at position 338 on the FIX protein, and in fact had a preferred embodiment in which the change from arginine to leucine was included in a selection of 3 other amino acids that could be changed at that position. So, what happened? The patent was held valid, and it really came down to whether or not it was obvious to try that substitution of arginine to leucine at position 338 with a reasonable expectation of success. And the judge was quite swayed here by the secondary evidence. No one had taken any further steps since the prior art, before the patent, for over 10 years, to make any other changes at this position 338, even though it was accepted by both sides that that kind of work would have taken 2 to 3 weeks to do. It was also of importance to the judge that this position 338 was within a kind of conserved region on the polypeptide, and so people wouldn't be thinking about making a change there because you might have an impact on folding, which might have an impact on activity. People had been looking at making changes outside of that region. Arguments by Pfizer that there was lack of funding for this kind of research, or that there was a moratorium on looking for gene therapy treatments for haemophilia B after the death of a patient in the late 1990s, didn't hold much sway with the judge. And he was made a particular comment that when this mutation was found actually in a patient with deep vein thrombosis, it was a real game changer for the field of gene therapy treatment for haemophilia B. He therefore made a primary conclusion after reviewing the secondary evidence that there was a pointer towards inventive step. He then went on to look at the primary evidence from the experts, and in particular at the role of these 3 amino acids that were included in the preferred embodiment in Stafford, and came to the conclusion based on the expert evidence that that preferred embodiment was a scientifically meaningless bit of patent drafting. And I think by that he means that they weren't grouped together in any way that meant that those changes, that position would lead to a successful treatment for haemophilia B, but they were grouped in that way more likely on the basis of a kind of typical biochemistry assessment of how you'd put the amino acids together on polarity, non-polarity, and so it didn't mean anything when they were being looked at in the context of these proceedings. So why is it important? It's an example of how secondary evidence can be key. Long gone, I think, are the days where secondary evidence was one of those things that it was kept in its place and in its box. And it was, as I mentioned earlier, running a couple of cases this year, and in this case, successfully. There was also a cautionary tale in this decision on the reuse of expert witnesses. They had a witness in this case who had been used quite a lot in other jurisdictions, most notably, I think, in the Netherlands and the US. And during that time, the judge had felt this person had spent too much time in the company of lawyers and potentially forgotten their obligation as an independent witness to the court, gave long pauses before answers to questions that were put to them in the witness box, and I think really felt that they felt the need to toe the party line. And so the comments in the judgment are quite strong in that regard from a judge, and really lead to a little bit of thought about the reuse of experts again in proceedings going forward.
So we now enter into the top 5, and at number 5 we've got Sandoz and Biogen case. So this related to the natalizumab product, and background is that the natalizumab is associated with an increased risk of a disease called PML, which is a very serious brain infection caused by something called the JC virus. And the patent in question was one from Biogen, and they had a patent for a method for evaluating the risk of developing PML. And their patent had 2 steps. The first step was about determining the anti-JC virus titer in a serum or plasma of a patient. And step 1 then went on to explain exactly how to perform that with the stages of the assay. And then step 2 was about determining that a patient would be at high risk of developing PML if the anti-JC virus index is bigger than 1.5. And so Sandoz brought these proceedings to seek to clear the way for the launch of its biosimilar natalizumab product and their own assay. And there were lots of questions in this judgment. It was another very big judgment with lots of interesting points on construction and validity. But the one we're going to focus on today is the one on territoriality. Because Sandoz said, so Biogen had counterclaimed for infringement and saying that the method which Sandoz wanted to use would infringe. And Sandoz's defense was, well, no, our method is not performed in the UK, so it cannot be captured by your UK patent. And the Sandoz method involved the clinician in the UK placing an order for JCV testing, taking blood samples using the supplied materials, and then couriering those blood samples to a third-party house outside of the UK where the assay would be conducted. And then the clinician would log on once the results were in to view the results. So the question for the court is, does that fall within the scope of the UK patent in terms of an infringing act? And the court looked at, there's 2 steps of the patent. So the first step, which was the actual assay step to determine the anti-JC virus titer, was clearly carried out outside of the UK. That was the thing which was couriered off and carried out there. And then when you look at the second step of the patent, there were 2, you could break that down into 2 parts. The determination of the index value and the determination that a patient would be at a high risk of developing PML if the value is greater than 1.5. So the determination of the index value itself was part of the assay, which was carried out outside the UK, so that was clear. In terms of the determination that you'd be at high risk of developing PML, that is something that the clinician would look at in the UK. But the court considered it was artificial to sever those 2 points because the patent was drafted in a way that the invention was such that it was deterministic. If the index value was greater than 1.5, that would show that there would be a high risk of developing PML. And so you can't then separate what the clinician is looking at to see is the value bigger than 1.5 from the determination of the value itself, which is all carried out as part of the assay abroad. And so the court considered that Sandals should be afforded the a UK territoriality defence. And he also noted that the use of the method, so the clinician using the results of the method in the UK to inform a patient or determine how they treat the patient, is distinct from actually using the method itself. So this is important. It's a development of the case law in this area, of which we don't have that many cases. The Menashe case, the Court of Appeal case a good few years ago, the RIM case, and then more recently in 2017, the Illumina case. This is quite, in ways, it's similar to the Illumina case because it's both related to methods where part of the stages are carried out in the UK and arguably other stages are not, and both related to testing. But the outcome is different to Illumina in that the method under Illumina was for detecting the presence of nucleic acid of fetal origin, and the preparatory and sequencing processes were all carried out in the UK, and the judge there considered that the things which were done offshore were the automated computing aspects, and they weren't the substance of the invention. So perhaps now we have another data point with different facts, different type of claim to give us a bit more of a line as to where you can draw the line as to whether a method is carried out in the UK or outside for the purpose of patent infringement.
Okay, we used to do SPCs as a separate little section. I'm going to try and bring it into the mainstream now today with the case of Neuron, not to be mistaken with Neurim, and the Comptroller General of Patents. So you'll see on the left of the slide just a brief recap on Article 3 of the SPC regulation, which you need to satisfy in order to obtain your SPC. You need a product that's protected by a basic patent in force, a valid marketing authorization to place that product on the market as a medicinal product. You need to have the product not already being the subject of an SPC, and the marketing authorization that you rely on to be the first marketing authorization to put that product on the market as a medicinal product. The definition of product is in Article 1B, and it's to the active ingredient or the combination of active ingredients in the medicinal product. So the Neuron case related to Article 3B and the valid authorization to place a medicinal product on the market. Neuron used a patent for their application which protected the combination of sulfonamide with levodopa and PDI. And they used a marketing authorization which had been held by the UK IPO and the High Court to cover only sulfonamide. So there was a mismatch between what was covered by the basic patent and what was covered by the marketing authorization in terms of the product. And so before the UK IPO and the High Court, the application had been refused. It went on appeal to the Court of Appeal. And despite arguments from Neuron looking back towards the Advocate General's opinion in Mediva from quite a long time ago from the CJU, that the court should take a broad and theological approach, particularly in relation to Article 3B, that would give a outcome-driven approach to this. The Court of Appeal followed the trends of the UK IPO and the High Court, refused the appeal, and the application was therefore not granted. In doing so, Lord Justice Burse, who gave the leading judgment, felt he was quite sure that the judge had correctly identified and interpreted that the product in the marketing authorization was sulfonamide alone. It didn't matter that as the therapeutic use of the medicine in the marketing authorization documentation was that the sulfonamide would only ever be used to treat Parkinson's in combination with levodopa, He said, and the previous lower decisions had also said, that that related to the use of the product and not what the product is itself. And following the decision in Santen, which overturned New RIM, the use of the product is no longer to be taken into account. The mismatch stayed, and as I said, the application, well, the appeal was dismissed and application not granted. Lord Justice Burse was also faced with a kind of late application for expert evidence to try and explain what was in the marketing authorization document, or try and help explain that to the court. He refused that, not only for it being late, but took the opportunity to say that looking at these marketing authorization documents shouldn't need an expert, should be a relatively simple task, and it ought not to require minute analysis. So why is this case important? It confirms a relatively strict interpretation of Article 1B, which has been taken in the UK. It gave the guidance that I just mentioned on how to look at the marketing authorization documents and other documents which you might look at in terms of supporting the application and what is the definition of the product. There were also some diverging decisions across Europe. The UK refused the application, but other countries did go on and grant it. It's not something which is unfamiliar in the world of SPCs, but it shows that that problem still exists. You may also be aware that there is a series of questions referred to the Court of Justice at the moment in the Halezyme reference coming out of the Czech Republic, or Czechia, in relation to the interpretation of Article 1B in the Halezyme case. In that case, just to briefly mention, the Halezyme are seeking an SPC on the basis of a combination of two applications, but one is trastuzumab and recombinant hyaluronidase. In the marketing authorization documents, the hyaluronidase is listed as an excipient. In the UK, the UK IPO and the High Court said no, if it's an excipient, it can't be an active ingredient. And recently, the permission to appeal to the Court of Appeal was refused on the papers. So that's the end of the road for it there. But there is the reference still ongoing for everywhere else in Europe. So while there might be a little bit of diverging decisions in Europe, the position seems to be quite clear in the UK on the definition of Article 1B.
Right, next up we have the Interdigital and Lenovo decision, which was the second ever FRAND determination in the UK. And this was the Court of Appeal then reviewing that decision. So there are lots of different points, so we can do a little whistle-stop tour through them. The court covered a lot of different of the kind of key fundamental principles of FRAND determinations, including what should the rate be? Should you use a top-down cross-check? Whether past sales should be limited by the limitation period? Whether interest should apply, and how to deal with issues of conduct. So let's start with the FRAND rate. So this one was interestingly overturned. The Court of Appeal overturned Mr. Justice Meller on the question of what the correct FRAND rate should be. And so to understand that a bit more, we have to look at how the first instance court determined the FRAND rate. So the way this is done is using comparable licenses. So these are other licenses to Interdigital's portfolio, and working out from that an unpacked rate, so a per unit rate which can be derived from those licenses. And that then can be applied to Lenovo sales to work out what the license rate that Lenovo should pay. Now, the comparable licenses covered both past sales and forward-looking sales. And it's quite a normal industry practice that the past sales have a discount. So there's a past use discount in the licenses. And the first instance court considered that those past use discounts were non-FRAND elements of the licenses. Yet, when determining the license rate that Lenovo should pay, the court considered the blended rate from the blended unpacked rate from the comparable licenses, which took into account both the past elements as well as the future elements, and so therefore was baking in that past use discount to the license that he was determining for Lenovo, which the Court of Appeal considered was not the FRAND approach, because the past use discounts were not FRAND elements, and so the rate which the first instance judge had come up with was sub-FRAND. So what the Court of Appeal did was it estimated a revised FRAND rate, which was around 30% higher. The court did note that it was not that pleased that both parties had gone for their jackpot cases instead of presenting any middle ground to really help it to work out with any more precision what the revised rate should be. On top down, so this is an alternative method for working out calculating a FRAND rate, which is looking at the share that of the patent holders' patents of the total number of patents for the relevant area. The court just noted that the comparables approach, where you're looking at market data, other licenses which the SEP holder has entered into, is much more reliable than top-down. So there's a question mark as to whether top-down is really that helpful for future cases. Then we come on to the cross-appeal from Lenovo. So Lenovo said that they shouldn't have to pay for all past sales since the beginning. Rather, limitations should apply, so they only need to pay for the past 6 years. And the Court of Appeal dismissed that argument, saying that limitation periods are irrelevant to FRAND. That is a creature of damages, and a FRAND determination is not a damages inquiry. Rather, the correct question is what a willing licensee and willing licensor would do, and a willing licensee would pay for use from day one, and so limitation period should not apply. Similarly, for interest, given the point in time where these FRAND determinations come in, this is a long time, particularly in this case, after the implementer has entered into the market. And so the court considered that interest, it had the power to award interest, and it should award interest, so that the timing of the payment is economically neutral and to take into account the time value of money, and also not encourage implementers to delay in making payment. The final point which the Court of Appeal looked at was conduct, and in fact noted that it's mostly irrelevant to FRAND determinations. So in terms of how the parties have behaved in the past, what really matters are the offers which are on the table, and only in truly egregious cases should conduct be taken into account, which may make an impact on interest and costs. So this is very important to us in this field because it's the second ever FRAND decision with Court of Appeal guidance. It does bring about some interesting questions. So after the first instance decision, there was a feeling that perhaps the rate which was determined was a bit implementer friendly. But now that the Court of Appeal has uplifted that by around 30%, maybe it balances more the implementer and patentee interests. And one way of looking at that is you can see that on appeal, Interdigital was seeking something which was around double what the Court of Appeal decided, and Lenovo is seeking something which is half. Then in terms of the other impact that this has, it may be able to help to streamline future FRAND proceedings because, first of all, there's the top-down cross-check, which the court is saying is not as relevant or reliable as a comparables approach, and then also past conduct, which, while very relevant for determinations in particularly Europe, or I should say the continent, now the court is saying that's not so relevant to the FRAND litigation here.
So our top life sciences case this year relates to rivaroxaban and a claim brought by no fewer than 10 claimants to invalidate Bayer's dosage regimen patent, allowing entry onto the market following the expiry of the compound patent and SPC in April 2024. Bayer's patent had Swiss form claims to the use of rivaroxaban for the treatment of thromboembolic disorders that were limited to use of a rapid release tablet and administration that was no more than once daily for 5 days. The generics in this case relied on phase 1 trial data, which was contained in a number of posters which were said to be read together. There were attacks on insufficiency and some added matter attacks in relation to amended claims, which we won't look at today, but we will be focusing on some of the points that came out from inventive step. But as you can see on the slide, we had not only a first instance decision in this in 2024, but also a quick Court of Appeal decision thereafter, and also some interesting interim injunction aspects, which we'll cover. So what happened? The patent was held obvious, and when it was being considered, there were said to be 4 differences between the phase 1 data that was in the prior art and the phase 2 data that was presented and covered by the patent. But essentially, all of that fell away, and it came down to the question of whether or not in a phase 2 study there would have been a reasonable expectation of success that the once oral daily dose would have been safe and effective in treatment. The posters in the prior art had data stated up to 12 hours, but they had graphical representations that went on for longer periods of time. And one of the posters in particular had a statement that the phase 1 data suggested that rivaroxaban was suitable for a once daily dosing regime. At first instance, His Honour Judge Hakon considered that there was no real technical barrier to the expectation of success, which is what we normally see. He said it was more of an ethical one, and suggested in places that this kind of expectation of success would be something which could be asked of whether or not there'd be a reasonable expectation of success, that the ethics committees approving the phase 2 clinical trial would give that approval and that it wouldn't be whether or not there was this technical level. Ultimately, as I said, the patent was obvious, and Bayer appealed, and one of its points of appeal was on that question of whether or not the legal standard for obviousness should be whether or not an ethics committee would grant approval for the phase 2 trial in these proceedings. On appeal, Lord Justice Arnold said that while it would have been better if the first instance judge hadn't been referred to the ethics committee approval, this didn't take away the decision on obviousness, because at points in the judgment, and in particular when he drew his conclusion, he had applied the correct test, and that was whether or not there was a reasonable expectation of success that the once daily dosing would be safe and effective for patients. So that kind of solved that question. As a timeline on the left of the slide here in relation to the interim injunctions, and it says just a little bit more, please, because you can see that a number of kind of short preliminary injunctions were granted. First of all, just before the loss of exclusivity to tide over essentially until the High Court judgment. That was given and granted by the court to maintain the status quo. The second injunction was granted at the handing down of the judgment, and that was given to basically place Bayer or the Court of Appeal in the best position that it could do if and when it considered any appeal. The Court of Appeal did grant permission for appeal on the papers quite quickly, and when it gave that decision for permission to appeal, it extended the interim injunction until the outcome of its judgment. So why is this important? Number of reasons. First of all, what does it mean for dosage patents in the UK? Is it going to be more tricky to defend those, or will this be a decision kind of confined to its facts? A little bit of interim injunction creep. We've seen a number of decisions in recent years challenging our previous positions on when interim injunctions will be granted, but here asking for several instances of short injunctions meant overall quite a longer period of an injunction was granted. I think that tied into the timing issues a little bit. In the Court of Appeal judgment, there was a postscript from Lord Justice Arnold who made a comment that the generics in this action had brought the actions too late. There was a decision of the at the EPO in October 21, but it wasn't until October 22 that the first actions started being filed in the UK. And to clear the way before a launch in April 2024, that then put the court under a bit of time pressure, and it felt then that it had used its time and resources to deal with this, when really the emphasis should have been on those seeking to clear the way to start the action in advance. So whether this interim injunction creep will go away if the timing issue is adhered to, on that a warning from Lord Justice Arnold, we'll see. But positively, it does show an example of when the Court of Appeal can quickly get things through, give a quick hearing, very clear decision, which in this proceedings was needed.
So now we get to our number one case, which was the Panasonic and Xiaomi decision, which was in fact quite a controversial decision, with now divided opinion within the field as to whether it's been correctly granted. So I'll leave you to make up your own minds on this. So this was another SEP action, but it was one started by Panasonic in the UK and seeking a determination of global frown terms as part of their claim. So far, so normal. Also, parallel proceedings started by Panasonic in Germany in the UPC seeking injunctions, as is also quite normal there. And Panasonic had committed to take whichever license terms the UK court determined would be frowned. Xiaomi also, in response to the claim, committed to take whatever license terms would eventually be determined frowned by the UK court. And the frown trial was listed for October, with a judgment expected by the end of the year. So by the end of the year, there would be the expectation was that there would be a frowned determination with a license that both parties would enter into. So against that backdrop, which is, you could probably see similar to the Lenovo Ericsson backdrop, Xiaomi questioned why Panasonic was still seeking the injunctions in Germany and the UPC. Why was it continuing with those proceedings? And it said that it was wrong to do so, and in light of the fact that there would be a frown determination at the end of the year, it should instead grant an interim license to Xiaomi, which would mean Xiaomi would give it a rate, a lump sum, and that could be subject to the final frown determination. But in return, if there was an interim license in place, then there would be no infringement. So those actions in Germany and UPC would fall away. And so what it sought from the UK court was a declaration that a willing licensor in the position of Panasonic would enter into an interim license. And this application failed at first instance. It was Mr. Justice Leach who heard it, and he considered that there was no obligation on an SEP holder under the ETSI policy or otherwise to enter into an interim frown license. And there was no reason why it was illegitimate for Panasonic to enforce its rights in other countries in accordance with the laws of those countries. And it was, and he also considered he was not in a position to determine what an interim license should look like, because the frown determination hasn't happened yet. That was going to happen later in the year. So all in all, he thought there was no need to grant an interim license, and also the test of a declaration is that it has to form a useful purpose. And here, Mr. Justice Leach considered that the only real purpose in making the interim declaration would be to try and influence the other courts. So, because generally in Germany, for example, they really take into account willingness as a big issue for determining whether an injunction should be granted or not. And so he thought that really what Xiaomi were after was a declaration that Panasonic were not willing, so that they wouldn't get any injunctions in Germany. And he thought that was therefore overstepping the mark for comity if he were to grant this declaration. The issue was then appealed to the Court of Appeal, and who overturned the decision. And it was Lord Justice Arnold who gave the leading decision, who said that an implementer is the corollary basically to the Lenovo and IDC case that I mentioned at number 3, which is if you're going to have to pay, if an implementer has to pay for sales from day one, they are also entitled to a license from day one, provided that they're willing to take one. And given that Xiaomi has said that they're willing to take one, they've committed to take a license, why was Panasonic still continuing its proceedings in Germany and the UPC? And he considered that a willing licensor in those circumstances would enter into an interim license. And so he said it was inconsistent with the idea of that Panasonic were bringing UK action, seeking a FRAND declaration and determination, that they would then try and potentially force a settlement on higher terms, because the only reason he could see for those parallel proceedings was to create some pressure on Xiaomi. And he thought, well, that the only reason for doing that would then be to try and get a negotiated settlement, which is going to be on different terms than the court will ultimately determine our FRAND. So his point of view is really, well, if the UK court's going to determine FRAND, surely that, and everybody's agreed, surely that's the end of the story. And so he was said there is a useful purpose, because it could force Panasonic to reconsider whether or not they will enter into this interim license, which he thought they should do. And there was no issue for comity, because he thought it was entirely up to the German courts and the UPC courts to make their own assessment of conduct and grant appropriate relief as they saw fit. And then on the issue of what the interim license terms were, he also considered that wasn't an issue, because the court can make an interim determination, which would subject to the final FRAND determination. And he basically picked a number between the two offers on the table and went for the midpoint and say, okay, they're your interim license terms, and granted the declaration sought. So this was, as I mentioned, a very controversial decision. And I think the controversy can be seen by the dissenting judgment, which was by Lord Justice Phillips, who disagreed that it was appropriate to grant a declaration. He considered there was no obligation. He was basically agreeing with Mr. Justice Leach at first instance, no obligation to grant an interim license. That doesn't come out of the ETSI IPR policy or UK law. And he considered that the real purpose of this was to try and influence the German proceedings. And that is not a useful purpose under UK law, and therefore it shouldn't be granted. But then coming back to the way Arnold's point of view, Lord Justice Arnold's point of view, is he's not forcing, in his mind, forcing anybody to enter into the license. As he explains in the judgment, he's not attempting to interfere with how anyone else abroad will deal with their decisions. He's granting a declaration as to what a willing licensor would do, and then it's up to the parties whether or not they follow the guidance, and then up to the foreign courts as to whether or not they determine whether how that affects the relief that they should determine. So this then now addresses the open door which was left in Lenovo and Ericsson as to what should happen between the big outset of FRAND proceedings and the final FRAND determination, where the parties are agreed to take a FRAND license. But there may be more on this subject to come in the future, and there are definitely other cases which have been in the court since then, and I'm sure they won't end there.
Okay, so just a few words from me to wrap up. Last year I stood here and confidently told you that three things that would happen for sure in 2024 were that we'd have the first three of the cases on this slide here, and I was clearly wrong about that, because they haven't happened yet, at least in 2024. What I can be confident to say is they will happen in 2025, because they've already happened. So at least I'll be right about that next year. But Court of Appeal in Apple and Optis we'll look forward to speaking about next year, because that is a third data point from the Court of Appeal on FRAND. So that'll make the story a bit richer in terms of its variety. Merck Serono at the Court of Appeal is an SPC case. That's on cladribine, and it deals with the point of Merck's legitimate expectation as to whether or not they could have expected to have an SPC at a brief period in time when Neurin was the law and before Santen came in. So that's already been dealt with. And then at the first instance level in the Patents Court, Teva and AstraZeneca is a case about plausibility. dapagliflozin, and will be interesting to see, particularly because at the moment, following the apixaban case, the UK stands as a bit of an outlier in its approach to plausibility following G2 of 21, and whether, so again, it'll give us another data point as to how plausibility is being handled in cases like that when that decision comes out. The only thing I'm not sure about is the Supreme Court, whether we'll actually get a decision next year. We know for sure the Supreme Court will hear the emotional perception appeal because permission's already been granted. I can't tell you whether it'll happen in 2025. It might actually creep into 2026. We'll have to wait and see. So that's all to look forward to. Traditionally, we'd finish this roundup of patent cases with a session about the UPC, but the UPC is in such full swing now that we've just decided to hive it off and deal with it separately. So in your bags, you've got our UPC case review. We're not doing a sort of presentation like this about the UPC where we seat people down for an hour. What we've done instead is to coincide with the publication of our review last year, at the end of last year. That covered 18 months worth, and because it came out at Christmas, we sort of did a 12 days of UPC recording that's accessible via our website, and you have the hard copy in your bags. There is also podcasts that we do, and you can subscribe to those. So if you'd like a regular update on the UPC, tune into that. And other than that, just remains to me to say thank you again, and I hope you enjoyed the evening.